Hello everyone, welcome to LexTalk World Talk Show presented by Clickaway Creators. Today we have Etrus Tan with us. Etrus comes with a strong belief that young age is not the obstacle of being excellent and of being a lawyer. Etrus has consistently performed excellent during his journey as a litigation lawyer after being called as an advocate and solicitor of High Court of Malaysia from year 2018 to till date. His excellent performance, leadership, and litigation expertise got him to become the junior partner of Esther on Tengku, Saiful, and Sree during his first of practicing in 2018 to head the litigation department of the firm. In 2019, he was promoted as managing partner of the firm. He is one of the mentors of ELM Insight, which is an initiative by Malaysian law students for the development and learning purpose of Malaysian law students. Recently, Etrus has also been listed by Asian Legal Business Malaysia Rising Stars 2021. So, hi Etrus, thank you so much for joining us.
Hi, Nikki. Yes,
It's a
really
pleasure.
grateful and thankful for this opportunity.
It is a pleasure to have you here. So, Etrus, tell us about a complex legal issue that you worked on, and also describe the complexity, and also tell us how you actually approached it.
Okay, I think when it comes to the complex legal issue, perhaps I think as a lawyer, I believe we must always actually go through a lot of legal issue in our daily work. Okay, and I would like to share one of the complex legal issue that I come across recently, which is by this month. In fact, early of this month, which is one federal court case. So in Malaysia, the highest court is actually federal court, okay? And we just won one case in federal court just by the early of December. And that case is actually a case on the infringement of trademark. Because for me, I'm also a lawyer that focus mainly on the intellectual property. So when it comes to the infringement of trademark, right, okay, I believe that all of us also, we heard about trademark, right? I mean, a lot of businesses like KFC, like perhaps, okay, they will have their brand, even Apple, they have their trademark, the Apple icon to be registered so that it can be protected, and no other competitor can try to confuse their customer, or rather take the attention of their customer away by using something similar with their trademark. So there's a whole idea of registration of trademark. And in that particular case that we have in the early of December, okay, which is this month. So what happened in this case is that, okay, for this case, right, okay, we are acting for the plaintiff, which is a company on the personal beauty care, okay, with the trademark called Royal Expert White. Okay, so what is the interesting fact about this case is that, okay, for this Royal Expert White, right, okay, it does have disclaimer in the trademark. What does it mean, disclaimer? Disclaimer meaning in the sense that, okay, when it comes to the trademark, like Royal Expert White, the word expert, the word white, all these are the words that very widely used in general. So when it comes to registering for the protection of the trademark, okay, for this particular word like expert and white, right, okay, there is no exclusive protection will be given to those companies, okay, even though they register the trademark, they have this word expert and white, they register it, and they got the approval, still there is no exclusive protection. Reason being is, okay, because it's not really an exclusive word, okay, it's a general word, okay. But because of such a law, okay, on the disclaimer saying that there's no exclusive protection, there's one pitfall or rather a loophole per se, okay, in the sense that, okay, there are also other competitors trying to take advantage of my client by using on the word of expert white, okay. If I may, I like to just do a screen sharing, okay, on the trademark of my client, if I may, also on the trademark of the competitor, which is which is in the sense of, okay, what happened in this case, okay, for the case that I mentioned just now, my client trademark is called Royal Expert White, and the defendant mark is actually called Real Expert White. See or not? It's that because of the word expert white, it is a disclaimer. So what happens is that there are competitors who try to take advantage on this on the word of expert white. They are also having a word of expert white in their own mark. So there is, in order to have a confusion, and to a certain extent also can causing the confusion in the potential customer, and then for our kind of customer, eventually, or rather the market will get it wrongly and buy product, which they are supposed to buy from our client, that eventually go and buy from the other side. because of the use of the word as required. But what happened to this case is that, okay, at first, we won in the High Court, okay? We won in the High Court for our client. And then the defendant, they appeal to the Court of Appeal, okay? And they won in the Court of Appeal. So what happened is that, okay, that time the argument of both parties is that, okay, we argue the word of expert white, yes, it is disclaimed, correct? We never deny about that. But the issue here is, okay, even though it is disclaimed, okay, the court, when it comes to determine whether or not there is an infringement of the trademark, the court should still consider the disclaimed word as a whole. What does it mean? In the sense that, okay, for this case, okay, not only the competitor using the word, the defendant not only using the word expert white. In fact, the font style of the word are the same for both marks. And even the positioning of the font expert white is also the same as our client mark. And even the other essential feature, the positioning also very similar to our client case. That's why we are telling the court that, look, in this case, yes, the word expert white, they are disclaimed word, correct. However, but the court should not just exclude it, should not just ignore the word in total, but the court should take into account of the disclaimed word in consideration with other part of the mark as a whole, in order to do a better comparison on whether or not there is a likelihood of confusion in both marks. Okay. Now what happened is that Court of Appeal did not buy our argument. So Court of Appeal eventually decided against us. So the appeal of the defendant was allowed. But anyway, thank God in the sense that we also proceed. We have our clear instruction to proceed also to appeal to the federal court. But in Malaysia, before we can appeal to the federal court, right, there's a threshold that we need to meet, okay? Basically, we need to get a leave to appeal to the federal court first. But in order to get a leave to appeal to the federal court, okay, there's a threshold which is that either, okay, your case, it does have the novel question of law, okay, new question of law that never ever decided by the federal court, or there are questions of law that concern public importance and is of public interest for the federal court to decide upon, okay? So what happened to this is that, okay, thank God we managed to also convince the federal court that, look, when it comes to this claim word, what are the treatment, how should the court view it, okay? This is in fact a new area of law. Because for IP, which is the intellectual property, so far in terms of Malaysian law, there are still some room and some space for further development. So these claim words are in fact one of the areas where the Malaysian law so far, the federal court hasn't decided. That's why for this case, okay, the federal court also granted us a leave, and we managed that go to appeal before federal court. And we also, in order to convince the federal court judge, we have to do a lot of homework. To what extent? We need to even do a research to get a UK law position, even the Singapore law position, India law position, to the EU law position, and even Jerusalem position of law, in order to convince the court that, look, in other countries, other jurisdictions, they also do not just like totally ignore the disclaimed word, okay, just like that, but rather the court, the other jurisdiction, they do look at the disclaimed word as a whole with the trademark. So in that sense, in our case here, the Court of Appeal, okay, we submitted that as erred because they only look at the disclaimed word, then saying that, okay, it is disclaimed and they should just ignore. So this is already a wrong approach, which the federal court eventually agree with us and with us on this point. So eventually we won in the federal court for our client. So that is a success that I have recently for this month, which I would like to share with everyone. So for this case, because it is a decision made by the federal court on the disclaimed word, therefore it's also a landmark case in Malaysia when it comes to the use of disclaimed word in the trademark, especially when the court determines whether or not there's an infringement of the trademark, whether or not there is a total passing off. Okay, in terms of the trademark, whether or not there is a likelihood to cause confusion, the court, when they are disclaimed word, the court has to, okay, view the disclaimed word as a whole with the trademark. Okay, so in that sense, this case actually given more protection, okay, to those companies who register their trademark. Therefore, my advice to also the company is that do register your trademark, even though your trademark contain disclaimed words. Yeah, I think so far, I hope that I have answered your first question. Back to you.
Absolutely, absolutely. Now, in the era of legal technology, what are the mostly common use tools for you?
Okay, for me, I would say that legal technology is really important for a lawyer because all of us, we do have time constraint. Sometimes, especially right now in Malaysia, our court, they have a KPI, they have a target to hit in the sense that they need to make sure that cases can be disposed in 9 months time. That's why for us, okay, we do have a very tight deadline to meet, okay, to submit the cost paper. So one of the legal technology tool that I like to recommend, perhaps to share with everyone, okay, is actually Lexis Advance. Yeah, certainly I'm not the ambassador of Lexis Advance, but I really find it's a really, really great tool for lawyer because in the past when I was a pupil, when I was an intern, in order to get the legal research, to find the case law, because you see, when it comes to lawyer, stand before the court, we have to argue based on the case law, based on the past as to the case precedent that the court has decided in the past. But to find out all these relevant cases, okay, let's say we do not have a proper system, but have to really use very manual manner, or rather it's a very traditional way, it would take a lot of time. I still remember that time that when I was an intern, I got to even over 1 week, I had to stay over the firm overnight, okay, 3 days over more than 3 days over 1 week, stay overnight at the firm, just for the purpose of getting the case law that's supporting, okay, my lawyer cases. Yeah, that was a tough time. But I'm really grateful with the introduction of Lexis Advance. Lexis Advance is something like Google, okay, in the sense that like Google, whenever you click anything, you can easily get a file from Google. Same as well for Lexis Advance. When you key in the keyword, okay, then it will appear. The cases that contain the keyword that you key in, and then you will also be able to find out what are the most recent case law, the federal court decision, corporate decision, and not only in local Malaysia, in fact, even in other jurisdictions as well. You can easily get them done. Like for example, the research used to be you're going to spend about, maybe 1 day or even more than 10 hours. But with the Lexis Advance, it really shortened the time of research. I would say sometimes even 2-3 hours, you can do a very fantastic and extensive research. That's why I would say that as a lawyer, yeah, we really, really need to embrace the legal technology. I would say this is one of the good ones that I have always resort to. And second, perhaps a second tool that I would also like to recommend is also for me, for my firm, we do have a Google Calendar system. I do use a Google Calendar, okay? Although it sounds to be normal, but Google Calendar is also can be useful because in the past, we lawyer, we tend to have a physical diary. Yes, physical diary is good, okay? However, sometimes, it needs to have a very tight SOP to make sure that every lawyer, especially I'm the managing partner, and I'm also in charge of my litigation department. So there are a number of lawyers in that department, and yeah, they do assist me to go to court to attend case management. So sometimes, for example, let's say everyone just have a manually jot down that kind of schedule or rather a diary book, then chances very high is that they might not be able to communicate to me at the first possible time as to what are the date that the court has set up or fixed for the trial or for whatever purpose. And then when I got to attend other matter, I may accidentally tell the court on the date that actually my other lawyer might have already fixed for me for other cases. So that is the likelihood of this kind of confusion. But with the Google Calendar, which seems, in the sense that it can synchronize all the calendar of all my lawyers, then in one glance, I'm able to make sure that all the dates are properly taken care of. So there won't be any confusion, there won't be any mistake, and everything can run very smoothly. Yeah, there's also another tips I would say I have to share with everyone on the technology that assists me when it comes to my legal practice. Yes, back to you.
That was beautifully explained. Now, Etrus, as we all know that time is money in any profession, and in legal, it's most of all. So how do you ensure to make the best use of your time as an auditor?
Okay, for me, one of the ways is that definitely in the sense that I'm not really just do the case solely by myself. I do have a team. Okay, I find that when it comes to have a team, okay, sometimes it can be really helpful in the sense that with other people effort, we do it together, we can really make things happen in a shorter period of time. However, let's say there's no proper communication. Chances very high is that, okay, when you have more people, ended up because of the miscommunication, it will make the whole thing to be even delayed further. or rather some quarrel or argument may even come into picture. So what I do is always that, okay, for our case here, we always have two lawyers, okay, to assist me. So what I will do is that I will always, when we have a new case from client, we will first get all the facts, okay, and the information from the client. That's one thing. Second thing also, I will get all documents from my client first to make sure that, okay, is that whatever documentary proof that supporting the information that they have given to me, okay, are already with me, even before I file the case to the court. So that I will really be able to know the case thoroughly. Then my whole team, we can do a very thorough analysis on that case itself. Instead of, I do believe, I do come across a situation where, okay, some of the lawyer, perhaps they might, sometimes they might just listen to their client, and then they might have pleaded certain things, in the pleading when it comes to the commencement of the court proceeding. But ended up, when it comes to the pre-trial stage, they get a document from the client, whatever they got there might be contrary to what their client said. So they will have a difficulty in the sense that they need to amend it again. So there is a need to file amendment application, and there's a need, to even frame their case, strategize the case over and over again. So it's not effective. That's why what we always do is that, okay, in order to ensure productive, is that get the thing done correctly at the beginning. At the beginning, when you have done it thoroughly, you get all the documents from the client, get all the facts correct without any assumption. Then upon that foundation, do a thorough analysis and discussion with your team. So when everyone we have, in the sense that I will not only just based on my argument and my strategy, I do give my team, my other lawyer a chance to also let me know their view. That's where we discuss, we analyze, so we come up with a structure or direction that all of us will agree. From that point, okay, that's where we will also plan out what are the things to be done, what are the strategy, okay, and even when there's any application, what are the points that we are going to, okay, argue about, what are the arguments that we are going to rely on. So with all these things done properly, right? So when my lawyer, my assisting lawyer, okay, they do the submission, they draft the submission, okay, because we have done a thorough communication already. So it's like when they submit to me, from there also I can make some amendment and finalize a draft in a shorter period, as compared to a previous way that I came across where I was an intern. Okay, what happened is that, or rather where I was a pupil. So I came across a situation where, because there's no proper communication, so sometimes the lawyer who's supervising me, they might just ask me, you do it yourself. You're going to be independent, you do it yourself without, come to disturbing me. So after I had done it, okay, when I submit my work, they might find that, it's not something as expected by them. So they may even want to change the whole thing, or even tell me to do a very sharp 360 turn. So it will waste the time. That's why what I always do believe is that at the beginning, have all document in ready. At the beginning, have all the communication done and come to a consensus. That's where the team, from that point, they draft the document, draft the cost paper, and from there also I review their work. Then it will be more efficient and productive. There's my sharing, and perhaps, yeah. Back to you.
That was again very well explained. Yeah. So, Etrus, do you have any tips to share on how to be excellent in litigation works?
Yeah, and like what I mentioned just now, actually to be a litigation lawyer, to be excellent is not really so difficult from my personal point of view. I would say that, okay, as a lawyer, two things they are the most important thing that we must know, especially as a litigation lawyer, because I'm a litigation lawyer. Okay, for other area, perhaps I would like to reserve it. But for litigation, I would say two most important factors is always facts and law. So when you get the law correctly, especially the latest law, okay, you get yourself updated with the latest law. You understand that the law involved in the cases that you are handling now, okay, thoroughly, then, okay, you won't go wrong. First thing first is the law must be there. Second part also is the fact. To what extent, as a lawyer, you know about the fact of your cases. That itself, especially the fact part, right, okay, and also the law, sometimes you really need lawyer to burn the midnight oil in order to make sure that, okay, we ourselves really understand thoroughly and accurately the law and the fact that involved. So for me, okay, one of the secret, I would say, or rather a tip is that, really, when it comes to document, my client give it to me, sometimes it could be voluminous. It could be 10, it could be 20 bundles. It could be. It could be, but what I will do is that still I will go through. Even though yes, I have an assistant counsel to go through also, but I myself will still go through as well. Sometimes it could be tiring because of the work quite a lot. But in order to ensure the quality and also my client interest will not be compromised, I will still go through page by page to make sure that all the point, all the fact, all the document, I will not miss out any important point. In fact, I also do come across situations where sometimes there could be just because no thorough or analysis of document, certain important point were not brought up, even by my learned friend, by my opponent lawyer. That's why I find it's really a miss. Yeah, that's why as a lawyer, it's really important for us to know the fact and the law. When you know these two very well, I would say that when you have done the preparation well, 80%, 70% is really in your hand already. I do believe on that. But certainly there are sometimes could be situations that beyond your control. But so that we have done this fact and the law is in our hand, I would say chances to win are really high. Yes, back to you.
All right. So also I would like to know, as a young lawyer who's practicing in the legal industry below 10 years, what are the challenges in your legal career that you have faced before and how did you overcome it?
Yeah, I would say yes, correct. As a lawyer who practiced below 10 years, one of the challenges I believe not only me, most of the young lawyers will face is that the prejudice or rather the perception that the society generally have is that, hey, young lawyer, you might know nothing. Young lawyer, you might lack on experience. Young lawyer, you might not be able to perform well and will not be able to represent me well. I mean, that are the stereotype of the typical perception that the society may have. But for me, I'm actually proud to be a young lawyer in the sense of why. Especially just imagine, for me, even though I'm a young lawyer, like what I mentioned, it's not when it comes to practicing, right? Yes, I do agree with the seniority of a lawyer has. Perhaps the lawyer may have more experience, but then that doesn't mean that it's an absolute kind of situation. Why? So the senior lawyer, even though they may have already practiced many years, but sometimes they may not get themselves updated with the law. They might not have the time to re-go through document page by page. So as a young lawyer, the good thing about us, the advantage of us is that we are young, we are energetic, we are able perhaps to cook more night, I would say, to do more extensive research, to go through document more meticulously. From there, when your fact is there, when your law is there, okay, even though you have to stand before the High Court judge, even though you have to stand before a court appeal judge or federal court judge to argue your case before them, okay, or even when your opponent counsel is a 20-year, 30-year lawyer, when you have your fact and you have a law in your hand, you have done all the preparation, I really believe that, okay, even though you're a young lawyer, you still can make a difference. Because this is what I have gone through myself personally. Yes, I do have cases, at court appeal, federal court, where my opponent lawyer, they are already 30 years lawyer, 25-year lawyer. Yeah, it's like even before I was born, they're already a lawyer to that extent. Sometimes that could be the gap of the difference in terms of the year of practicing. But even then also, there are situations that I gain a victory. That's where year of practicing, it is not something that is so absolute in determining whether a lawyer can perform well or not. But rather to me, I think that one of the important points is that whether the young lawyer, okay, or senior lawyer per se, whether they have the right value or rather whether they have a right mindset in the sense that whether you really want to do your best, deliver your best to your client. I think that's very important. No matter how senior a person is, let's say they don't want to get updated themselves with the latest law. Let's say they don't really care so much, okay, or rather they care, but maybe not that much for their client, then to a certain extent, their client interest will be compromised. But for me, I myself, I do believe that as a lawyer, yes, I do believe that it's a calling. Although it sounds to be a bit traditional, but I do believe that being a lawyer is a calling. So I do owe a duty, perhaps to also God, okay, that I can be a lawyer. So that's why I also want to really perform well in my role as a lawyer and also to help the society. So with the passion, I believe that is also one of the points that, can help me to overcome. I would say sometimes it's a passion, it's a hard work to really overcome that kind of perception that society generally have toward young lawyer. It's really the passion. It's our passion, it's our effort, it's our preparation, it's our perseverance that will really make people to view us differently. So whoever young lawyer that listen to this perhaps interview, I do hope that you will not get discouraged, but rather believe in yourself and deliver your best. Back to you. Thank you.
Thank you so much for sharing such great insights with us. So we look forward to having a chat with you again in the future on some other training topics. So for our viewers, if you like this chat with Etrus Tan, please like and share this video as much as you can. And also subscribe to ClickAway Creators YouTube channel to appreciate what we do. And you have more coming from the legal space. So this is Nikhil from LexTalk World signing off.